When your case goes all the way to trial, when the judge takes a break to let the jury go out and rest for a little bit, is it ever appropriate for one attorney or the other to have private conversations with the judge? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Lawyers call this ex parte communications. What does that mean? It means that one lawyer is having a private conversation with the judge. And you know what? That's a big no-no. That is not to happen. That should never happen. You want to know why not? Even if the other lawyer, the defense lawyer, is standing 10 feet away, going through his papers, sitting at counsel's table, and now your lawyer is up talking to the judge privately. The defense lawyer, when he looks up, he has no idea what your attorney is saying to the judge. He has no idea what the judge is saying to your lawyer. He doesn't know if somehow your lawyer is colluding with the judge. He has no idea what's going on. He has no idea why they're both laughing. He has no idea why they're both looking over at you and pointing fingers towards you. Maybe they both belong to the same club. Maybe they go to the same restaurant. Maybe they ran into each other that morning and now had a brief chat. The problem is that the other lawyer has no idea what the two of them are discussing. Now, if this was reversed and the defense lawyer is up there chatting with the judge, and now your attorney is by his table or talking to you, and now he glances over and he sees that the defense lawyer is having a whole private conversation with the judge, again, he doesn't know what they're talking about. He doesn't know if they're talking about your case. He doesn't know if the judge is trying to get him to offer up money. The problem is the people who are left out of that conversation don't know what's going on. And so in law, we call that an ex parte communication. And all that really means is that somebody is being left out of that communication. The person who's not part of that conversation may perceive that bad things are going on or that they're saying things against this particular lawyer. So how do we remedy that? How do we make sure that doesn't happen? Simple. The judge is not supposed to have private conversations with one side or the other. It's that simple. If you want to go ahead and talk to the judge, I have to wait for my opponent to come with me and we both walk up and talk to the judge. This way, maybe the judge wants to talk about scheduling of various witnesses. Maybe the judge has to talk about procedures. Maybe the judge has to talk about a legal issue. The point is, it has to be done together. So let's say I arrive in court early one morning and now I want to address something with the judge about something that happened at trial the day before. Guess what? I can't do it. I have to wait for my opponent to join me as we have this conversation. Otherwise, now it creates a perception problem. When is it actually appropriate for the judge to meet in private and talk to an attorney privately? You want to know when? It's when we have settlement conversations, when we have settlement negotiations and now the judge is involved. In that instance, it is entirely appropriate for the judge to talk to both attorneys at once and then to send one of them out while he now has a private conversation with one of the lawyers. And then when he's done with that lawyer, now he sends that lawyer out and he tells the other one to come in. And that is critically important for the purposes of trying to negotiate a particular case. And that's really the only time a judge can have private conversations with individual attorneys. So why do I share this quick information with you? I share it with you to help you understand how these types of cases work here in New York. You know, I do recognize and I understand you're likely watching this video because you have questions or concerns about your own matter. Well, if you have not yet started a lawsuit and are thinking about bringing a case, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.